So thanks everyone for joining us for this presentation by Miller and Chevalier with our friend Isaac Stonefish from Strategy Risks. We're really excited to talk about the Uyghur Forced Labor Prevention Act and how your company can come up with your due diligence approach for dealing with the new law. My name is Virginia Newman. I'm counselor at Miller and Chevalier, and I have a background in China, and I work on anti-corruption, trade, and anti-forced labor laws. And I work closely with Richard, and Isaac is here from Strategy Risks, and I'll let them introduce themselves.
Sure, thank you. I'll go ahead. Good afternoon, everyone. Richard Mojica, I'm the practice lead for the customs group at Miller and Chevalier. I'm also a former CBP headquarters attorney in the Office of Regulations and Rulings. And increasingly, my practice is focused on matters concerning the intersection between trade or customs and human rights, including CBP's enforcement of the WROs and now the UFLPA.
Thanks, Richard. Thank you, Virginia. My name is Isaac Stonefish. I'm the CEO and founder of Strategy Risks, which is a research firm which focuses both on quantifying exposure to China and then working with companies, suppliers to help them understand and manage their China risk, often in cases of figuring out what their exposure is to Xinjiang or to the Chinese military or to other problematic areas of the Chinese state. Also, like Virginia, a longtime China person, lived in Beijing for about 6 years and am now in New York.
Thanks so much, Richard and Isaac. So as Richard previewed, we at Miller and Chevalier increasingly deal with issues related to CBP's enforcement of the Tariff Act and anti-forced labor laws. Mariana, if you could flip to the next slide, I'll just give you guys an agenda of what we'll be discussing today. First, we'll give a brief overview of the Uyghur Forced Labor Prevention Act. We're calling it the UFLPA for short. We'll discuss some of the issues related to CBP's forthcoming implementation of the Act. And then we'll go into what we're calling the UFLPA game plan. So a framework for your company to evaluate and to address the risks associated with importing goods that may or may not contain materials from China or otherwise affected by this law. And then we'll discuss action items that you can consider to leave this presentation with, things you can do right away, and then we'll have a Q&A session. So first, just giving a background overview of the UFLPA. Most people on this call are probably already familiar with the substance of the law, but it was passed in late December. It creates a rebuttable presumption that goods that are made in whole or in part in China's Xinjiang Autonomous Region or by certain entities are inadmissible to the United States. So this essentially means that if you're importing goods that have any component that is made in Xinjiang, Customs and Border Protection will assume that those goods are not admissible to the United States based on the forced labor concerns associated with that region in China. The UFLPA also requires the Forced Labor Enforcement Task Force, of which Customs and Border Protection's parent entity, DHS, is a part, to come up with an enforcement strategy for enforcing the law. So although the law was passed in late December, on June 21st is when this enforcement strategy needs to be submitted. And it's also when CBP will start enforcing the rebuttable presumption that goods that come from Xinjiang are not admissible to the US. The enforcement strategy, that's what we're all kind of waiting on to see what the mechanics will look like in terms of implementation, but it needs to include products that are considered high sector or high priority sectors for enforcement. It'll also list out certain entities that are believed to be sourcing from Xinjiang or that work with other entities that participate in problematic government programs in Xinjiang, including forced labor, pairing assistance programs, poverty alleviation programs. And then it'll also list out individuals that work with the XUAR government. The final kind of most important component of the UFLPA is that it's supposed to include guidance to importers. So The Forced Labor Enforcement Task Force is currently coming up with this guidance to importers. It hasn't been released yet, but that guidance is supposed to include steps that due diligence that companies can take and that they should take to ensure that they're not importing goods that are made with forced labor from Xinjiang. And then it'll also include the evidence, the type, nature, and extent of the evidence that importers can use to demonstrate that their supply chains are free of forced labor, and also that their supply chains don't have connections to Xinjiang. So that's just kind of a high-level overview of the UFLPA, and I'm going to let Richard discuss some of the questions and areas where we're lacking clarity on what the enforcement will look like.
Yeah, thank you. So CBP will begin to enforce the UFLPA in 3 weeks, as Virginia mentioned, on the 21st of June. Yet, to date, CBP has issued very little guidance on how it will conduct enforcement and what it will be required of importers to comply with the act, with the new law. So in the past month, CBP has updated its UFLPA website to include 2 sets of documents that I'll mention. The first is the text of what's known as the known importer letters. These are letters issued by CBP to companies that, as stated in the letter, previously imported merchandise from locations or entities that are subject to the act, potentially subject to the act. And the purpose of that letter was twofold. On one hand, CBP was notifying importers that any future entries of merchandise may be subject to an enforcement action, including seizure, forfeiture, or penalties. I'll note as a sidebar that CBP has not issued any penalties, or at least any penalties that are publicly known to date. And second, CBP was urging importers to conduct effective due diligence. And CBP mentions in the letter that it considers supply chain tracing an exercise to ensure that the suppliers and of every component are mapped to ensure that products are free of forced labor. So that's one communication. The other one I'll mention, which is the second bit of guidance that Customs has issued to date, is a one-pager on the enforcement mechanism applicable to the UFLPA. So there are 2 takeaways there. One is that CBP mentions that it will detain merchandise under a different regulatory provision than what was relied on, or what has been relied on, for WROs. So the practical effect of that is that once detained, the government will have, CBP will have 30 days from the date that the merchandise is presented for our importation to make an admissibility determination. So basically to determine whether they're going to release or exclude the merchandise. If Customs doesn't act within 30 days, then the goods are automatically excluded, which then opens up the possibility of either destroying or exporting the merchandise. What's important here is that under the WRO regulations, as many here that are listening know, the importer gets 3 months to submit proof of admissibility, and then Customs takes on that admissibility package and makes that determination. In our experience, sometimes weeks after that information is submitted. So we are, without a doubt, going to be dealing with a tighter timeline that is going to make it more important for everyone involved to make these determinations in a faster pace. And then the other takeaway from that one-pager is the evidentiary level. The evidentiary standard under the UFLPA is clear and convincing evidence. The WR regulations articulate an evidentiary standard to detain, but it does not articulate a standard to release the merchandise. So there's really nothing else beyond that at this point. It's been well reported that guidance should be coming this week. And in fact, CBP has a webinar tomorrow and some others after that, where I anticipate the additional guidance will be discussed. But as of now, again, 3 weeks out, importers are really clamoring for more guidance. And indeed, there are, in my opinion, some very important questions that have not been answered. So for example, the standard to detain merchandise under the UFLPA is, in my mind, still unclear. If CBP detains merchandise under the UFLPA, will CBP tell you why that merchandise was detained? I ask this question because in the past, they have not, beyond referencing the applicable WRO. Likewise, the standard of release is a showing of clear and convincing evidence that there is no forced labor. So how does CBP expect importers to prove that? CBP has confirmed in our conversations with the agency that the UFLPA will have a much higher standard of proof in terms of the burden of the evidence. But a question that we have is, if the importer attempts to rebut the presumption and fails for whatever reason, will CBP come back and explain why, such that the importer can address that issue or not? Again, in the past, CBP has not, and that has led to some functional issues in trying to implement an effective compliance program around that. Another question is whether CBP will continue to detain under the existing WROs, or whether those WROs will be subsumed under the new UFLPA. The effect of that would mean, again, that there would be a higher bar, higher scrutiny associated with UFLPA detentions. So that's another piece that people are waiting to hear. I know there's been some buzz around these WROs being subsumed, but we'll wait and see what the guidance says. There's a question on the entity list. Will it be made public? I think that's a very important question. The importing community, I think, is expecting that it will be, but we're not certain, in part because CBP has to date been reluctant to adopt a list-based approach. So that's still an open question. How will CBP handle admissibility reviews at scale? Again, if you have 30 days and many items are detained from the number of different importers, how is the agency going to process this at the given pace to make determinations within 30 days, or will it? It may not, allowing it to that time frame to lapse and leading to the automatic exclusion of the merchandise. Will CBP provide guidance to importers that are trusted traders and give benefits to trusted traders that differs from the general population, so to speak? Trusted traders have been advised that they can be kicked out of the CTPAT program if they don't comply with these new standards, which is fair. But at the same time, I think a lot of these trusted traders are expecting to see benefits from their participation in a way that perhaps differs from what the rest of the importing community has. And there's an opportunity here for CBP to articulate that. And I guess the last one is on the question of penalties. My reaction to the known importer letters that I mentioned earlier is that CBP was laying the foundation for imposing penalties for failure to exercise reasonable care. So for negligence, for failure to conduct adequate due diligence, which is different from intentionally importing restricted merchandise. So will CBP impose penalties for failure to exercise reasonable care under 19 U.S.C. 1592 or not? Again, so far, as far as we know, we haven't seen any penalties for failure to exercise reasonable care, and that remains one of the top issues in our mind as we work these legal issues. So next slide, please. So given all these questions, I mentioned only a few, and I know there are many more. We've been receiving them on the chat. We've been advising clients to adopt a game plan that assumes that they will be operating in gray areas. So the plan we're laying out today, and Virginia is going to kick off and walk you guys through, is rooted in a couple of key assumptions that are pessimistic, essentially. One is that the guidance will not contain the level of detail that you need for your company to establish an effective due diligence program. In other words, guidance will be more high level and applicable to a broad base. And so you will need to take some steps to customize that guidance to make it applicable to your business model. Second, that the rebuttable presumption will likely be incredibly hard to overcome. The clear and convincing evidence, as we mentioned, standard is difficult by design. And so you want to put your efforts in the due diligence piece, the pre-detention bucket, so to speak, and not trying to be in a position where you're trying to overcome that rebuttable presumption. Third, that existing high priority sectors like the solar sector, the apparel sector, palm oil, et cetera, may be subject to additional or at least different scrutiny as a result of the UFLPA. Again, it's not a certainty, but it's certainly a possibility that as a result of kind of a broadening of the scope of CBP's review, we're talking companies have to expand the scope of their diligence efforts as well. And finally, that there's going to be a broad enforcement in additional sectors. So, customs has been focused on a limited number of sectors to date, and we are expecting, or at least our game plan assumes, that this will expand beyond those sectors, and that some of the sectors that have not yet been identified by the government but have been mentioned in a number of NGO reports and so on will be caught up in this enforcement sweep as well. So with that, I'll turn it to you, Virginia.
Thanks, Richard. And just to add to what Richard was saying about the additional sectors being targeted for enforcement, some of the targeted enforcement sectors like polysilicon, for example, these reports precipitated CBP honing in on those industries. So now we're seeing reports issued by universities or by nonprofits, and we think that those are worth paying attention to because CBP's enforcement has trended to follow those types of reports in the past. Next slide, please. And please feel free to ask questions on the chat as we go. We'll turn to them at the end, but feel free to go ahead and log your questions in there now. So now we're turning to the due diligence game plan. Most people on this call, or probably a lot of you, have heard of supply chain mapping. So this is really meant to go through the process of how you can conduct due diligence in light of all of the uncertainties that exist about the UFLPA, beyond just kind of the simple answer of map your supply chain. So we're meant to give you kind of actionable, practical tips, taking into account what we do and what we don't know. So the high-level steps are: 1, to appoint your cross-functional team, develop a process to identify your higher risk products and suppliers, conduct due diligence, and make decisions based on company values in light of some ambiguity regarding the legal framework, and then ongoing monitoring. So next slide, please. Okay. Step 1, this might seem straightforward, appoint a cross-functional team, but we've seen companies kind of step in this in the past with not having all of the appropriate stakeholders at the table. The appropriate team should include both internal stakeholders and your external advisors that you rely on in the course of conducting this diligence. For your internal team, you'll obviously want legal and compliance there, investor and media relations, because you need to make sure that anything you're communicating about your strategy here or about your diligence or potential enforcement is aligned with your risks and how you're assessing them, and then what you're actually doing on the legal side to do the due diligence. You obviously want to include procurement there, your ESG, CSR, or sustainability teams, the product teams, government relations, sales teams, trade compliance. A note on the ESG, CSR, sustainability teams. In approaching the UFLPA and figuring out how do we kind of boil the ocean and deal with this law that requires us to look back in our supply chain so far, you might have, and a lot of clothing companies will, other companies as well, you might have supply chain mapping already done to some extent by your ESG, CSR, and sustainability teams. You want to leverage that if possible, and also make sure that any information you get can be leveraged back into your sustainability programs. So after, and then on the external team, there's ESG consultants, there's several different auditors. We just got a great question about auditing teams, and then outside legal advisors. So just knowing who you're going to rely on as you deal with the uncertainty and face potential enforcement. You also want to identify who's going to make the decisions regarding whether you're going to continue working with a supplier. We'll talk about this a little bit more later on, but for a lot of the suppliers and diligence results that you get, you're not going to have a clear-cut, straight answer on whether a supplier needs to be removed from your supply chain under the UFLPA. Despite, no matter what the guidance contains, it's not going to be granular enough such that you have absolute certainty on all of these decisions. So you need to set up thresholds when you conducted your first round of diligence, or when you commissioned a more detailed investigative report. Arm your decision makers with how they're going to make those decisions such that they can execute based on the plan that you've set out. And then finally, we kind of already touched on this, but develop plans for communicating with your relevant stakeholders. You want to make sure you're aligned internally at the company so that the sourcing department, your media relations department all know how you're approaching this problem, and that folks aren't kind of stepping out of line and issuing communications that don't make sense given the overall plan. And then also making sure that you're able to align how you're speaking to your customers, to your investors, your suppliers, and other external stakeholders. Next slide. Okay, this is probably the, I guess, most important step. So identifying your higher risk products and suppliers, and this is where we've seen companies have the most questions about how to conduct due diligence in light of the UFLPA. So in the pre-UFLPA world, discrete industries knew that they were being targeted. So we had solar panels, apparel, tomatoes, and they knew which inputs or which products CBP was targeting. So you could map your supply chain just for that high risk input. For example, if you're importing hoodies, you could map the supply chain for the cotton in that hoodie. And that's how we've sort of been discussing a product-based approach to conducting due diligence and to identifying your highest risk suppliers. That is still ideally the way to go about this. Identify all of your suppliers, map the supply chain down to the source, get full visibility into the supply chain, and then conduct due diligence on those suppliers to determine if you have any connections to Xinjiang or to the listed entities under the UFLPA. But there are going to be a lot of companies now that maybe import hundreds of different types of products, and they don't know all of the inputs that are in those products. How do you approach due diligence when you might have a supplier network of thousands of suppliers and you're not positive what your highest risk products are? In that instance, there's also the ability to kind of take the full pool of suppliers that you know, and then conduct a risk segmentation approach on those. So looking at, using the sourcing team, using the contracting team, the product teams to figure out who are all of our suppliers. Let's go from there and try and figure out who we need to conduct further diligence on. And it'll be critical to have the involvement of the product teams and the sourcing teams so that you know what the inputs to your products are. For example, one of the products that we've heard talked about recently as potentially coming under the enforcement of CBP under the UFLPA is aluminum. So, you and the general counsel's office or whoever else is sitting on your cross-functional team might not know which products you import that are made of aluminum. And so you'll want to involve the contracting teams and the product teams to make sure that they can help you identify which of your many products might be the next to experience heightened enforcement or might be identified as a high priority sector under the UFLPA. A lot of companies will probably do a combination of diligence for both of these approaches. So you'll want to both look at the high priority products that you import, but then also if you are in a high priority sector, take a deeper dive look at all of your suppliers that you do have information or access into. And a lot of how you actually deploy this will depend on how high priority your sector is, or are you importing some of these high priority items that are going to be made by CBP in addition to those that have already been released. Factors to consider when you're looking at the pool of suppliers generally and what level of diligence you want to conduct. You want to look at supplier location in China, obviously whether they supply one of those high priority inputs from CBP's perspective, if they've been named in any of the NGO reports, and then also if it's just a critical product to you. So if you import a really important component that you use in later manufacturing in the US, or if you import a really high value item that contributes to a lot of your company's revenue, you might want to conduct heightened due diligence on that line, regardless of whether you think it's a high priority item for enforcement. And that's because, as we've seen time and time again here, if companies don't proactively do this due diligence and mapping and priority problematic supplier identification early on in the process, the likelihood of successfully doing it in time to respond to a concern from CBP is very low. So these are our factors that we want folks to consider. And then I'm going to pass it off to Isaac to talk a little bit about what the diligence itself might look like.
Thank you, Virginia. As Richard and Virginia were making very clear, there's a lack of detail on what CBP is looking for. And this is very likely done by intention. The US government wants US companies and other global companies to reduce their exposure to China, and especially to Xinjiang, where upwards of 1 million Muslims have been imprisoned in concentration camps. And for company perspective, leaving aside all of the human rights issues, it is a very important piece of your regulatory risk. And dealing with it smartly can not only manage that risk in the United States, but also manage that in China. There's a way to do this without jeopardizing supplier relations and without putting your people in danger, whether they be Chinese passport holders or not. So, on to the actual diligence of companies in your supply chain. The idea is to get a sense of what type of links CBP and other US stakeholders might see as problematic, identify those in your supply chain before outside sources do, and then work to remediate that so that before the goods come in for CBP to look at, or before a nonprofit organization or a journalist is looking for these things and can identify you, you've already removed the problematic company from your supply chain. So what are things that CBP and others are looking for? The most basic is a presence in Xinjiang. Is there Xinjiang in the company name? Is there a city in Xinjiang in the company name? Does the company have a concrete, clear relationship with something known as the Xinjiang Paramilitary Construction Corps, the XPCC, which is a sanctioned entity? The issue here is not whether or not these Xinjiang companies are explicitly using forced labor. The assumption that the US government and many other US stakeholders have is that if they are based in Xinjiang and if they have Xinjiang in their name, then they're too close to problematic behavior for it to be even able to be proven one way or the other. And then a quick ethical point on that, if they are a Xinjiang-based company, they very well might be doing the right thing and not using forced labor, but the mere fact of proving that one way or the other will jeopardize them and their status as doing it. I hate to make the comparison with 1930s and Nazi Germany, but Xinjiang right now is an incredibly fraught place. And so suppliers and US companies have to be very, very careful with how they engage with companies on the ground in Xinjiang, whether the ones who are acting in ways that we find positive or ways we find negative. It's a very dangerous situation and one that has to be handled with great care. So that's the first order of degree when it comes to Xinjiang. The second is companies outside of Xinjiang that either work directly with those companies, are owned or partially owned by those companies, or participate in forced labor transfer programs. So a factory in, say, Eastern China's Jiangsu province might be using 6 or 7 Uyghur laborers that were forced to leave Xinjiang and work in this factory under coercive conditions. in a way that would still trigger the UFLPA? Or is that Jiangsu factory minority owned by the Xinjiang government or by a Xinjiang-based investor? The Chinese economy is far more dominated by state sources than the US or other global economies. So it's certainly not uncommon for a factory doing something that feels, in the US sense, very far from the state or the Communist Party, but having a significant ownership stake or even a minority ownership stake from a Xinjiang-based entity. Beyond that, things get murkier, but still trigger areas of risk. Has the company met with officials from Xinjiang? Has the company made investments in Xinjiang? Has the company contemplated investments in Xinjiang? All of these pieces of information are very valid in putting together a risk matrix. And the idea is gather the information, rank the companies both on their level of risk and also on their value in your supply chain, and then start making decisions based on that. A final note, I think we'll talk a little bit more about this later too. We don't recommend having frank conversations with the suppliers themselves about these issues. Not that they can't understand them, not that a lot of them aren't very intelligent and very cognizant of what's happening in Xinjiang, but you're putting them in an uncomfortable position where they have to choose between US regulations and Chinese regulations. And it's always better to try to avoid putting people in that position.
And just to jump in right there, so in the context of working with Miller and Chevalier, we've definitely seen many companies work directly with their suppliers to gather traceability documentation. That's been the existing framework under CBP's enforcement of the WROs. And so whether you're going to gather traceability documentation, whether you're going to interact directly with your suppliers as you frame this risk for your company and conduct the due diligence, I think a lot of that will depend on the pre-existing relationship with those suppliers, whether this is a conversation you've already broached with them or not. And really it is a case-by-case decision of whether you do want to work directly with suppliers. Isaac's approach is one way of sort of kind of doing this diligence before you go all the way deep down into your supply chain if you do have it mapped. And then just another brief reference is that we have also talked about adverse media screening. There's several different ways to go about this, but we do think it is really important, regardless of which provider you choose, to make sure that your adverse media screening looks at both Chinese and Western sources. Because perception is what's important here in terms of CBP's potential enforcement. If they think that you're sourcing from an entity on one of their lists or from an entity that sources from Xinjiang, your goods will be subject to that rebuttable presumption. So we just wanted to make that note that people consider that as they go through their adverse media screening.
Hey, Virginia, let me add a point here. So the first one is that one thing we realized early on is that it made a lot of sense to team up with consultants that are specialists in this field to do this work. And many of the responsible sourcing departments at companies already had a lot of these type of relationships. In other cases, we have developed relationships with firms and people like Isaac who specialize in this type of diligence. So part of what we have done is facilitate that connection between specialists in various fields, depending on what the matter calls for, and routing that, channeling that through the law firm to preserve attorney-client privilege around some of these very sensitive issues. And then the second point here is that Isaac and his firm present a certain type of diligence. In an earlier slide that Virginia delivered, there was a reference to ESG consultants. Well, an ESG consultant is a broad term that could mean someone like Strategy Risks that conducts in-depth due diligence on a company's connections to China. You can also have other type of providers that are becoming incredibly useful in this space. In one instance, we've worked with companies that help collect the documents that customs would require in the event of a detention, right? The information that Virginia will touch on momentarily that we refer to as traceability documentation. production records, purchase orders, proof of payment, so on, to demonstrate the provenance of the various inputs that used to make the product that's imported to the United States. And then, of course, the other one is, in the context of apparel, for example, companies that are able to trace the so-called DNA or fingerprint of the cotton used to make a particular good. So that's another type of due diligence provider. These are solutions that we know Customs is also looking at and try to inform its overall enforcement picture. And so, all of this to say there are different types of diligence providers. They offer different approaches, and all of this it needs to be kind of baked into this overall strategy, because different providers will call for different suppliers will call for different challenges that can be met with slightly different configurations of this broader team. So, sorry, go ahead.
Yeah, I think that's exactly right. That there are, we have the adverse media screening, the ability to gather traceability documentation, and commission investigative reports for suppliers. The UFLPA changes the framework because now the rebuttable presumption is so hard to overcome, right? So whereas before, it might have made sense to gather traceability documentation for one particular product that you think is going to experience heightened enforcement. Now it makes sense to think about that as you're conducting the diligence in the first place, of if we really think that there are these public allegations about this supplier that CBP will believe warrants our goods being targeted. Do we want to go through the effort of gathering traceability documentation, or do we want to try to avoid importing that product? So this is kind of setting the stage for that decision-making at the next level. All right, Isaac, I'll pass it off to you for the next slide.
Great. So a lot of these, there we go. A lot of these questions on where to trigger a risk rating comes down to company values and also company exposure with China. So I'll talk about company exposure with China first. For companies that don't sell all that much from the Chinese market, for companies that have lighter touches on imports, for companies that don't have JVs with Chinese companies, it can be easier to take a more muscular approach in the United States on following these rules and really leaning into ESG values or sustainability values. For companies that have larger footprints or have really integral supply chains in China, those companies are often more conservative when it comes to identifying problematic links in their supply chain. But either way, there are companies that rank high enough on a risk level that they really need to go immediately to legal or outside counsels like Virginia and Richard here. Those are companies that based in Xinjiang or have direct relations with the XPCC or other sanctioned entities, or have mentions in Chinese media about participating in the Xinjiang aid or other forced labor transfer programs, because these companies could be very problematic to US suppliers. And regardless of what one's boycott risk is in China, getting identified as a company that works with one of those companies in China in, say, Reuters or the New York Times doesn't help you in either market. So to speak about it more specifically, the first question is to figure out, once you've identified those problematic companies, do you keep working with them? Do you cut them off immediately? Do you figure out if there is a way to work with them, possibly via remediation or other types of methods? Do you stop importing from them to the United States, but possibly work with them elsewhere? It's a strategy that I think a lot of folks will try. I think from a regulatory perspective, it'll probably be fine. I think from a PR perspective, depending on how noticeable the change is, it could be something that raises some eyebrows. It's a strategy that US companies in China have been taking already, where they'll source goods from Xinjiang for the domestic Chinese market as opposed to for export. But for certain companies, there could be other PR risk or potentially future regulatory risk for that, and then exiting the relationship. There's a lot of points that we've made so far that I'll keep emphasizing on this idea of gray area. it's going to be very unlikely that your companies will be very explicitly involved in forced labor in ways that you can firmly document. But the way that the law is set up and the way that the norms are being shaped in the United States, it doesn't need that burden of proof. It needs other links to Xinjiang. So figuring out what level you want to draw the line as a company is a really, really important exercise to do. And it's really important, as you probably all know, bringing in ESG people, bringing in media people, bringing in people from across the company to have this really important discussion. Another point I'll make on that before handing it back is, while you're looking into Xinjiang, it's good to keep other considerations in mind. One of them, for example, is the Chinese military. With US-China tensions quite high, and with the war in Russia-Ukraine, there's a lot more conversation in DC about the ability for US companies to work with the PLA. It's worth, while you're rethinking your China supply chain based on Xinjiang, to also keep in the back of your mind that there are other ties between Chinese companies and Chinese entities which could cause regulatory risks and PR risks for you in the United States. And if you're doing this as part of a more holistic rethink of your supply chain, other issues like the PLA, like Chinese state security, are worth thinking about as well.
Thanks, Isaac. Yeah, I think that's a really good point, and I'll address that on the next step, talking about ongoing monitoring. But just to add one bit of color to what you were discussing with regards to the gray area, this is so important for companies, because no matter what level of detail the CBP guidance includes, and no matter how broad-ranging that list of entities is, there's still going to be entities that are on the line. For example, you source from a supplier that has a parent entity that sources from Xinjiang, or that has a parent entity that has operations in Xinjiang. The way that the UFLPA is written, it's not clear whether the entity lists would encompass that supplier, right? So it's not a black and white decision of, we know we need to exclude the supplier from our supply chain. The question then is, what is your level of risk tolerance? And so when we talk about making decisions based on company values and arming decision makers with the right information, the question is, what are the allegations related to the supplier, or how are they connected to suppliers that have allegations against them? And what is the potential cost of enforcement to you? Are you going to lose this entire product line if this does come under the scrutiny of CBP? And so based on that, are you, concerned about the potential monetary value loss if you experience enforcement, or is it worth it to keep importing because it's such a valuable product to you? And then we also see a lot of companies that have made commitments to, for example, the UN Global Compact. And so living up to this kind of responsibility to protect human rights might mean something different for them and might be of a higher priority to that company than some other operators. So let's go to the next slide.
Virginia, let me add one point here, if you don't mind going back. I think our approach, and an approach that makes sense given all the ambiguity, is to have, as Isaac mentioned, a risk matrix type approach where different situations lead you to different decision-making paths. One of those decision-making paths that you touch on here is, well, what happens if you land in one of these gray areas? And the situation that you contemplate in the slide is, you hire someone like Isaac's firm to conduct due diligence on a supplier of potential concern. What comes back is a report that shows that there are connections to the area, but are, in your view, attenuated, right? So it's not a clear-cut investment, but as you said, perhaps you have a family connection, you have business relations between this entity and another entity of concern. And so it's not a decision that can be made easily, because it's not necessarily kind of a legal decision at that point. The decision maker at the company, and I think about this, so-called decision makers or decision maker all the time. What happens if I were to get a report like that on my desk and I had to make that call? And I think at that point, going back to the lawyers at the company and saying, is this legal or not, just kind of doesn't cut it. So because they don't necessarily going to have the answer. So it is at this point that sometimes pursuing a different diligence path is going to be the way to go. So Isaac's report is going to flag these concerns initially, but that may not be the end. And just as in the same way as a report from an NGO may not tell the full story, a report from one of your consultants that you hired may tell a part of the story, but one that you need to develop further. And it is at that point, for example, that you want to look into the potential of traceability documentation or direct relations with the communications with the supplier, especially if it's a supplier that you've had a long-standing relationship with, and say, look, we have this concern. What documentation and what explanations can you demonstrate to show that we can get comfortable around continuing to buy from you? And at the end of the day, I think all of this can be very gray, very complicated, but it boils down to a simple question, which is, if you are scrutinized by customs, do you feel comfortable telling them that you know the origin of the components and that you can defend the position that none of your components come from these, potentially problematic areas? So that's it.
Thanks, Richard. Okay, let's go on to the next slide. So the critical part of your due diligence is going to be ongoing monitoring. And because this is a very live, active issue that is not set in stone at this point, you need to have team members assigned with responsibility for monitoring the space. So you might, have internal team members that will tell you if a new report has come out, what CBP's enforcement has looked like in the early months of its implementation after June 21, and then also whether your particular industry is experiencing enforcement. This is something you can outsource to outside consultants or counsel, but regardless, you need to make sure you have a way to monitor news reports. You also should refresh your due diligence on a periodic basis. It might be on very short periods as the UFLPA is starting to get implemented. And you can kick it out to longer timeframes as this law crystallizes more in practice. Okay, let's go to the next slide. So here we've kind of gone through the due diligence game plan. Here's some other items for you to consider. Richard, do you want to take this off?
Sure. All right. So here's some additional items you may want to consider to fold into your game plan. Some may not make sense for you, but worth considering. The first is whether you want to engage CBP proactively. It's a question we get all the time. And I think the answer tends to vary on the specific situations. I think that there's a potential to get political capital if CBP is approached the right way. And one of those situations where we've done it is to seek to clarify what the company views as inaccurate media or NGO reports. There's a lot that's being written nowadays on this topic, and sometimes companies come to us to say, look, this is a news report or an NGO report that the information that is here is not accurate, and we feel that if we don't rectify it, this is one of these pieces of information that CBP can act on, or any other regulator can act on. So I feel those are the type of situations where it makes sense to proactively engage CBP to correct the record. Another situation that I continue to believe is one of that presents a pretty good opportunity is the trusted trader benefits, something I mentioned at the beginning of the presentation. There are a limited number of companies in the grand scheme of things that have been tagged by CBP as trusted traders. They've gone through the process. They're kind of in the elite of traders in the US. These traders, in my opinion, should be able to benefit from that in this context as well. And perhaps they are, but at least this is a time when CBP can articulate exactly how it is that being a trusted trader could give companies additional benefits in this space. So could they potentially get some type of prior consideration of the documentation to view whether it would be adequate or not? Could they receive more information than others have in the past as to why their goods are detained, or if they are not released, as to why they are not going to be released, why the company is being targeted, et cetera? I think, again, there's a lot of opportunity there. And another way is also requesting binding rulings. We have not seen binding rulings to date on the applicability of WROs. CBP headquarters issues these binding rulings and has been very active in promoting them as an alternative to determine whether your goods would be admissible upon importation to the United States. And so this is something that importers, I suspect, are going to consider more seriously going forward. And we're probably going to see an uptick in those rulings going forward.
Yeah, I like the way you said that, Richard, that there's a lot of opportunity there because this practice isn't crystallized yet by CBP. So, engaging with CBP and asking for information might yield information that would be useful to you. And we really just don't know. So it might be worth trying in certain instances.
That's right. Another point, make communications the result of careful consideration by the team. That is what we mean there is plenty of companies have gotten into uncomfortable situations due to its public messaging on Xinjiang. As such, if the company is going to say anything at all, it makes sense to involve this cross-functional team, involve media before the internal communications teams before doing so. I talked to a company last week who said, we're all for doing the right thing, but we do it quietly. That is one approach. But for other companies who, for a number of different reasons, including the fact that their brand may be staked on these sustainability, transparency claims, that is not an option at times, and it's important there to think of, well, okay, we're going to make claims about our supply chains. We need to be very sure that we're considering kind of all aspects of these kind of geopolitical issues. Another point that we like to offer is conducting transaction testing, or what we call mock WROs for high-risk products. We did that quite a bit in this kind of pre-UFLPA environment. We'll see how it works under the UFLPA, but it's pretty much going to be the same concept. Sample entries of important products to test the documentation that you could obtain in the event of a detention, and to run the type of due diligence that Isaac was mentioning on the suppliers to see if there's anything that you should be concerned about before it hits the news, before CBP detains merchandise, and so on. So this is an exercise that has worked pretty well, just to get a sense of if we need to move quickly, as we would in the event of a detention, how would we look, right? These are just mock exercises. Brief sourcing and contracting teams on requirements for UFLPA compliance.
I'll jump in here. So this is something that we've seen multiple times. A lot of companies have come to us asking if we can help them to craft their terms for supplier agreements to make sure that they're able to get supplier cooperation with efforts in order to respond to CBP detention notices, or just with their anti-forced labor compliance program more generally. This is going to be even more important in the post-UFLPA framework. You need to make sure that the sourcing and contracting teams are aware of what you should be including in the contracts so that you can work with your suppliers to effectively respond to CBP should you need to, because it'll be such a quick time frame and probably such a hefty burden to respond to. And otherwise, you might end up in a situation down the road where your supplier is unwilling to give you traceability documentation or unwilling to otherwise consent to the types of due diligence that do require supplier interaction. And just a final point before we go over to Q&A. We mentioned this briefly earlier, but if your company engages in broader human rights due diligence or has other due diligence related to, could even be anti-corruption or sanctions due diligence, which Isaac mentioned earlier, you want to make sure that this process is dovetailing with your other enterprise risk management and due diligence processes so that you're not leaving information on the table, not getting to take advantage of that information for purposes of the UFLPA, and also so that your sanctions, anti-corruption, or human rights compliance programs also benefit from what you learn in this process, because you will be spending resources on it. And so with that, I think we're done, and can switch over to Q&A.
We have a bunch of questions and not enough time to answer them. So, the first thing I'll say is that for anyone who asked a question, please feel free to email us and we'll respond to these questions by email. However, let's try to answer a few. Will you be providing the slides to the attendees? Yeah, sure. We'll send them along. Just send us a note and we'll reply by email.
I think the first question is a good one for Isaac. We ran into an interesting issue. We had a due diligence matter involving Xinjiang, went to some of the usual external vendors, but one of them turned down the work due to concerns that the business would suffer in China if they were behind this diligence. Do you think we'll see more of this difficulty with vendors?
I think we certainly will. It's something that we run into a lot. So we very purposefully don't have anyone on the ground in China or Hong Kong and don't work with Chinese companies, not because there's not a lot of fantastic Chinese companies, but so that we can avoid these very specific issues. It's very difficult for companies that have exposures to China, whether they be manufacturers or due diligence companies, to address these really sensitive issues that are really important for companies to address. So I'm not sure, because you're anonymous, who's asking the question, but do feel free to reach out if there's anything I can do to be helpful.
Thanks. And then another question here is, given the possibility of transshipment of Xinjiang products to other Chinese regions for repacking and then export, how effective will the UFLPA be in fulfilling the underlying goal of preventing forced labor products from entering the US market? Ineffective, somewhat effective, or impossible to verify? And then a follow-up question is, to what extent do you think companies will start sourcing outside of China altogether and outside of Xinjiang following the implementation of this law?
I would say that the goal of the UFLPA is less to prevent the export of goods made with forced labor and more to reduce US exposure to China and to Xinjiang. So the idea is not to root out forced labor from US supply chains. That's a really lovely goal, and hopefully we'll get there at some point, but it is to identify Xinjiang and other parts of China as problematic to US companies. So I think on that lens, it'll be very successful. And I'll turn it over to my other panelists for the second part of that question.
Yeah, Virginia, you should take the second piece.
Yeah, so the question is, to what extent do we think we'll see companies seeking to source products outside of Xinjiang or outside of China altogether? I think that a lot of companies have already started to look at potential changes to their supply chain, even years ago, in anticipation of heightened enforcement and just exposure to Xinjiang and what it might mean for their brand outside of the legal enforcement. So if those industries are indicative of how this might affect other industries that experience enforcement, I wouldn't be surprised if companies not only ship their supply chains outside of Xinjiang, but start to look into other options to reduce their exposure to China more generally. I personally, I love working in China and on these issues, so I hope that we don't have total split supply chains, but that's my response there. So
let me just finish by saying that we've worked with several companies that have moved their supply chain away from Xinjiang successfully. The solar industry is a good example of where the heavily scrutinized sector that has been, with some companies, have been able to do this successfully. And to end on a positive note, the result of many months working on some of these issues for some companies has yielded satisfactory results, in that after working hand in hand with CBPs on these issues, we have worked with companies in ways that have resulted in merchandise being released. So we go into the UFLPA with a lot of questions, but we have we also have a track record of seeing CBP release merchandise in a way that gives us some optimism that there will be a real process behind the UFLPA, and that once the parties get aligned as to what is necessary in terms of the information that needs to be submitted, how will be reviewed, and kind of get efficient around that, we'll be able to hopefully get this moving in the right direction.
Thank you guys so much for joining us. Thank you very much to Isaac and Strategy Risk for lending us our China expert Isaac today. And we really appreciate everyone participating. We will be available obviously by email or phone if you have any questions for us, and we wish everyone good luck preparing for enforcement.